Hello, I am doing grievance discussion case 3, safety gloves, discharge, just cause. Next slide. I'm the labor relations manager for Barrera Recycling Company, and I will prove that manager Rafael Gomez had just cause in firing Aaron McNamara. Local 37 Union, the United Paperworks International Union, has filed a grievance against the company saying that he did not have just cause. He did have just cause because she did not follow safety regulations. She had multiple warnings. She was violating her contract agreement. She had a 3-day suspension with clause and no more violations in 1 year, which she broke, and she was guilty of misconduct. Next slide. The description of the case is that Aaron McNamara had worked for the company for 20 years. She had transferred into the Los Angeles reclamation facility of Barrera Recycling Company in January. In that time, she was verbally reprimanded 6 times by manager Gomez for different safety code violations: not wearing a hard hat, not having proper safety glasses, for not wearing her safety gloves, for sleeping through her safety meetings. And she did not wear her safety gloves, as mentioned before, when she was sorting through glass, broken glass, and other recycled materials such as sharp tins, which could harm her. The 7th time she was reprimanded was in October for reading a magazine. She was then given a 3-day suspension with a written clause stating that if she had any more violations within 1 year, she would be immediately fired. On December 6th, not even 2 months later, she was caught by manager Gomez sorting through the recycling again with no safety gloves. She said she had left him in the car. She went to go get them, but when she returned, manager Gomez had fired her. The union filed a grievance saying that he did not have just cause. Next slide. Gomez did have just cause because in less than a year she had 7 reprimands. She had a 3-day suspension with a written clause saying no violations in 1 year, which she did violate. She broke 5 of her contract clauses for immediate dismissal, and she put herself and the company at risk. Next slide. Article XX of her contract for causes for immediate dismissal that she broke included disobedience, neglect of duty, refusal to comply with plant rules, sleeping, and reading magazines. Article XX1 of her contract states that within a year, all of these things will be wiped clean if the employee has no more warnings, which she did, and it was in less than a year. The contract is there to help both the employee and the employer, has both of their interests at heart, and she was violating these contract agreements and putting herself and the employer at risk. Gomez had just cause in firing McNamara. Next slide. Just cause is defined by Bud as, in short, requirement that employees be disciplined or discharged only when there is just cause, means that there must be a valid job-related reason for being disciplined or fired. Gomez had a valid reason for disciplining and firing McNamara. Arbitrators like to use Carol Doherty's 7 tests for deciding just cause. Dilts and Moore say this common law of discipline could be reduced to a series of simple questions concerning the way in which discipline cases were handled by the employer. They also say that these tests of just cause for discipline have been subject to controversy, but do provide for a predictable decision-making platform. Next slide. The 7 tests include: was the worker given advance warning of the consequence of his or her conduct? Was the rule or order or standard reasonably related to the employee performance? Was the alleged violation thoroughly investigated before discipline? Was the investigation fair and objective? Did the investigation reveal convincing proof of guilt? Was the employer's discipline non-discriminatory? Was the discipline reasonably related to the worker's record and the severity of the conduct? Gomez can answer yes to all of these questions, proving that he did have just cause. Next slide. According to these tests, Gomez did have just cause in firing McNamara. She had warnings, she had a suspension with a written clause, she knew the terms of her contract, and she knew she was violating them. She knew the safety regulations, and she knew she was violating them. There was no discrimination. All the employees had the same rules and regulations. Also, others had witnessed her violations, so there was proof of her guilt. Blitz and Moore say arbitrators use this test a lot. What this evidence clearly supports is that arbitrators overwhelmingly appear to rely on Carol Doherty's 7 criteria for just cause in framing their own decisions in discharge and disciplinary matters. Next slide. There's more research into Gomez's just cause in violating McNamara because of her contract agreement. Rahadran defined contract as, in the simplest of terms, a contract is an agreement between two or more parties that is enforced by law. A more complete version would be a written contract with an offer and acceptance and an exchange of consideration and requirement for competent parties. Zimonic talks about dismissing employees for violating safety regulations. If an employer genuinely and consciously believes that the continuing employment of an individual represents a health and safety hazard, they are entitled to dismiss an employee. This is very true when it came to Gomez's case and him firing McNamara. She was a risk. Next slide. Zimonic also gives 3 requirements for employers to follow when it comes to dismissing an employee for safety violations. Did the employee know the requirements? Employer was consistent with enforcement and policies, and the precautions were suitable to the employee and the work they were doing. The examples of previous lawsuits where employees were fired for not following safety violations were Frizzle v. Flanders for not wearing a gas mask, and Jenkins v. British Gypsum Ltd. for sleeping on the job. In 1995, Sims wrote, misconduct is defined as worker does not carry out duties, failure to follow rules concerning health and safety, tardiness, neglect of duty, and also a disruptive effect. McNamara was not following her duties and was not following safety regulations there, so therefore there was just cause in firing her. Next slide. Hopefully, for the outcomes of this case, the arbitrator will agree and realize that Manager Gomez had no choice but had to fire McNamara for safety violations and misconduct. There was just cause. Hopefully in the future they will have safety regulations added to the contract, including violations and punishment. Rahadran, Clark, and Whelan's safety issues specified in the contract should go beyond OSHA requirements, as those are generally well covered with existing reference specifications. I'm sorry, Rahadran said that. Next slide. Conclusion. According to the U.S. law, Gomez did have just cause in firing McNamara. She had numerous warnings, reprimands, suspensions, and a written clause that she violated. Gomez had no choice but to fire her because of her misconduct and her breaking her contract agreement, and she did not follow the safety rules, putting herself and the company at risk. Thank you.